Thank you, Your Honor, and I want to thank the Sutter County Superior Court as well for accommodating the public interest in today's proceedings, which I believe are of profound importance to our state right now. And I want to thank as well everyone who's come to the courthouse and who's tuning in. I think that it's something of great value. And we have all three branches of our government represented here in this room, which is appropriate in a separation of powers case. Judicial branch, well, Your Honor, of course, the governor, and Mr. Gallagher and I, my co-plaintiff, are members of the legislative branch, although these days it's starting to feel like we're full-time lawyers again. But in our capacity as legislators, we of course have our political views, our opinions, which we fight for, which we advocate for, same as the governor does. And everyone here in this courtroom and everyone watching has their own political views as well. Their own opinions, sharp differences of opinion, especially perhaps on the issue of the day, or as it's turned out, the issue of the year. And that's the response to COVID-19, the decisions made by the governor, the path moving forward. But this case is not about any of that. It's not a case about politics. It's a case about law, of course, we're in a courtroom. But it's about something more fundamental, as my co-counsel referred to. It's about separation of powers, and it's about the rule of law. And by the rule of law, we mean the vital principle that written words are binding on those in positions of power and constrain their actions. From this comes the basic feature of a free society: freedom from the arbitrary dominion and control of another. It's what gives life to the audacious premise that citizens, we the people, are not mere subjects of state power, but members of a community of equals and authors of our own political destiny. It's what makes possible the great American experiment of self-government, which on a historical timescale, after all, is still in its infancy, is still fragile. I believe that these foundational principles, separation of powers, the rule of law, Republican government, ought to be unifying, ought to cut through the cacophony and the dissension and the vitriol that characterizes our politics now more than ever. So it is my hope that having this public debate, resolving this issue in a public forum, can commit us anew to these principles and will have a salutary effect on the state of politics and society in the California of 2020. Because our commitment to these principles doesn't go away when we're in an emergency. The rule of law does not break down during an emergency. That is when it is most important. A well-designed system of government like ours has enough give in the joints to meet the exigencies of a crisis, but also has enough structural integrity not to collapse or to be transformed into something entirely different. And that risk that we will lose touch with our form of government is heightened when an emergency is no longer a transitory event, but has now lasted nearly 8 months with no end in sight, no even abstract discussion of when the state of emergency might end. Over time, deviations from the rule of law start to pile up. And as the norms of democracy take one hit after another, at some point it will put more stress on our civic institutions than they can bear. That is what this case is ultimately about. And we'll be discussing today two sources of law. The first, of course, is the California Constitution. And as we have representatives of all three branches, we've all taken an oath to the Constitution, which has a specific provision defining the limits of each of our authority. Article 3, Section 3, the powers of state government are legislative, executive, and judicial. Persons charged with the exercise of one power may not exercise either of the others except as permitted by this Constitution. And that principle, of course, came directly from the founding of our country. We started our opening brief in this case with a quote from James Madison in the Federalist, who said, "The accumulation of all powers, legislative, executive, and judiciary, in the same hands, may justly be pronounced the very definition of tyranny." We weren't the only ones who noticed that quote. The Supreme Court of Michigan cited the exact same statement in striking down that state's emergency services law in a case we'll be discussing more later. Now, eerily, the defendant in this case uses almost the exact same words as James Madison did to describe the present state of the U.S. government. Defendant has repeatedly claimed that the Emergency Services Act, the second source of law we'll be discussing today, quote, centralizes the state's powers in the hands of the governor. So the defendant maintains that the California Emergency Services Act does the very thing that the father of the U.S. Constitution described as the definition of tyranny and that our state constitution expressly forbids. Our case today, Your Honor, is simple. It does no such thing. And if it did, it would violate our own state's constitution. The laws of the state of California do not countenance an autocracy under any circumstances. They do not allow for one-person rule. They do not empower a governor to legislate, not for one day, and certainly not for 8 months with no end in sight. Shortly, my co-counsel will be delving into the evidence as to the order at issue in this case. But I would, to begin, like to provide some context as to the circumstances under which that order was issued. Because the state of emergency that we are under is unprecedented in several ways, in at least 3 ways. The first, which I've just mentioned, is the duration. The second is the sheer volume of executive orders that have been unilaterally issued. 57 executive orders changing over 400 duly enacted California laws. But the third distinguishing unprecedented feature is the kind of power that has been exercised. Both sides appear to agree, that the executive order in question, N-6720, was an exercise of legislative power by the governor. That has never been contested by the defendant in any of the briefing. We disagree as to whether this is allowed by the Emergency Services Act. In defendant's trial brief, he states that our interpretation, quote, would leave the Emergency Services Act largely toothless. The governor would be sidelined for weeks or months, hoping for eventual legislative action, while the earthquake, fire, or pandemic is raging. Toothless, that's how our interpretation is described. Yet in all of the evidence before the court, the defendant has not identified a single emergency action by any governor, any prior governor, that is inconsistent with our interpretation. And as the defendant himself says in the same trial brief, California governors have used the Emergency Services Act for 50 years to combat droughts, medfly infestations, wildfires, earthquakes, and now pandemics. Apparently, they all used it in a toothless way, because in these 50 years of droughts, medfly infestations, wildfires, earthquakes, defendant has not identified a single governor who created statutory law in the way that the governor did in this case. He cannot identify a single action of any past governor that our toothless reading of the act would have prevented. The only executive orders in the record that would have been enjoined by the relief we seek today are the defendants. It's the defendant who is using the act in an unprecedented way. It is the defendant who is acting on a new theory of the powers granted by the act, a new and boundless well of authority in the act that somehow escapes the attention of all prior governors that they've referenced, as well as the courts who have adjudicated the case law that's been discussed in the briefing. And so while the legal theory offered by the defense has shifted to some extent throughout the course of this case, ultimately they've landed on a particular provision of the Emergency Services Act, which has dozens of sections, but they've sort of characterized Section 8627 as some catch-all, which refers to the police powers, and have described this section as affording the governor, quote, plenary authority to govern, which of course would literally give him boundless power that would render the other 100 pages of the act superfluous. So I'm going to discuss later why that is wrong as a matter of statutory construction. But right now, I just want to underline what a novel theory of the Emergency Services Act this is. Because just as there is nothing in the record of any prior governor using an executive order to legislate, so too, there is nothing in the record of any prior governor ever citing this section, 8627, as the basis for any order. It's not in any of the several elections-related orders that the defense has produced in this case, and it's not in the cases discussed by the courts. It's not even mentioned. And yet here, this section 8627 has been invoked in 24 orders by Governor Newsom during the COVID-19 state of emergency, the one at issue in this case, and at least 23 others. So out of 57 orders that have been issued, 23 of them have cited Section 8627, which again, they've not provided a single example of any other governor citing once. And all of these orders do exactly what the order at issue here does: exercise legislative powers, unilaterally create policy. So let me just go over a few examples. My co-counsel will be discussing the order at issue in this case directly, N6720, in great detail. And these are all, Your Honor, in Exhibit G, although it might be more trouble than it's worth to flip through them, as I'll be just giving you enough to get a flavor for each one. So N5720 deals with debt collection. That established that CARES Act funds were shielded from any debt collectors. N5120 deals with paid sick leave. It provides that a hiring entity shall provide COVID-19 supplemental paid sick leave to each food sector worker who performs work for or through the hiring entity, and then goes through a whole variety of laws and procedures and requirements dealing with that new program. N6220 deals with workers' compensation. It says that any COVID-19 related illness of an employee shall be presumed to arise out of and in the course of the employment for purposes of awarding workers' compensation benefits if all of the following requirements are satisfied, and goes into great detail about those requirements. N6620 deals with teacher credentialing. It provides that candidates for a credential the usual test is suspended, but they must complete a different one and pass a commission-approved teaching performance assessment. Well, thank you. This is our court reporter. For those watching, I putting your fingers through stress, I'm sure. The final one I wanted to reference was N4420, which deals with price gouging, which is actually a topic the legislature has legislated on specifically to prepare for emergencies. And this provides that in addition to the prohibitions set forth in Penal Code Section 396, a person or other entity shall not sell or offer to sell any item from among a whole list of new goods and categories. There's a whole bunch of other topics addressed. How's my speed? We good? There's a whole host of other topics addressed: reentry proceedings, marriage licenses, tax exemptions, water shutoffs, foster youth placements. Now, we're not contesting the wisdom of these policies per se. I'm sure there are some that we would agree with as a matter of policy, and some we would disagree with. But the important point is that none of them went through any legislative process. We don't know what opportunity there was for any stakeholder input. We know there wasn't any opportunity for public participation. We don't know what special interests might have had a seat at the table. None of it was public. There was no deliberation, negotiation, compromises, veto gates, the things that characterize the legislative process in these policies spanning nearly every California code. So, Your Honor, this case presents what is truly a question of first impression, and that is whether the Emergency Services Act affords unrestricted police powers, which no governor in the record has ever laid claim to, but which the defendant here has claimed as the basis for 24 different orders, effectuating dozens of actions throughout many different legal codes touching nearly every facet of California life, without any legislative process or consideration of those policies in a public forum. We will argue that if this newly discovered bottomless well of authority is in fact a feature of the Emergency Services Act, then the Act cannot stand under our Constitution. And as a matter of fact, that interpretation which defendant would give it and is acting upon would put it on par with the law that was just struck down by the Michigan State Supreme Court. The court there, citing an earlier Massachusetts case that actually dealt with an executive action pertaining to elections, said, quote, that the law would provide a roving commission to repeal or amend by executive order under unspecified provisions, included anywhere in the entire body of state law. So we'll return to that phrase, roving commission, because that's what the Michigan Supreme Court found that the emergency powers of the Governor Act there provides, and that is what the defendant in this case argues that our own Emergency Services Act provides. So we will argue that these are the two options that are before the court today. If California law is as broad as the defendant argues in this case, affording unrestricted police powers and a plenary authority to govern, then it too must be struck down for the same reason that the Michigan law was. But if, on the other hand, California's law is narrower than Michigan's, as we argue, then the governor's order in this case, and many of his other orders, was not authorized by the Emergency Services Act or by any statute, and should be struck down for that reason. And the governor should be enjoined from issuing any further such orders, as has become a habit during this state of emergency.